according to Section 47 of the Land Act, a husband or wife cannot sell or transfer a land or landed property acquired within the marriage without the written consent of the other spouse. When the Gender, Children and Special Protection Minister designate Sarah Joa Safo appeared before Parliament's Appointments Committee, she answered questions on the property rights of women as they pertain currently in the country. Listen to her.
A very vexed but pertinent issue. I would like to know what your thoughts are on it. The property rights of spouses. The 1992 Constitution indicated that a law should be passed to protect the rights of spouses upon dissolution of marriage. It came to this House in the 6th Parliament and was withdrawn for further consultations. It didn't make its way back in the 7th Parliament. Would you take steps to address the issues that made it difficult for its passage in the 6th Parliament and ensure that we make some headway to giving effect to?
Yes, Honorable Minister for Gender. Paternity leave to assist women in maternity leave.
Thank you very much, Mr. Chair. Mr. Chair, I will start with the first question, which relates to Article 22 of the Constitution, which guarantees the property right of spouses. And the fact that this bill came before the floor, or came on the floor of Parliament and had to be withdrawn. Just as the affirmative action, there are a number of them that has come. I will give my honorable colleague the assurance that the whole House is expecting and the entire nation is expecting to hear that when I'm giving the nod, I would ensure that these laws are laid before the House, relayed, and for consideration and for the law to be passed. It is going to be one of my priorities.
You're welcome back. Please pay particular attention and join us have this discussion. We will open the phone lines in due course for you to join with your questions. The fight for women's rights, particularly in terms of holding property, has been a long-standing battle. Question: this new provision in the Lands Act, is it not a way of, if you like, a backdoor approach to give women what they have desired for long? And our Parliament has been almost derelict in passing the spousal property rights. Betty Mould-Drisu, under her leadership as the Attorney General, a bill was put in Parliament was made for the purpose of empowering women so that they will have some rights as far as property is concerned. But as we speak, that bill has still not become law. I'm very happy to be joined via Zoom by Sheila Menka Premo. She's Chair, Executive Council of LAWA, Ghana. And thank you very much for making the time to join us. And LAWA is the leadership and advocacy for women in Africa. That's the full meaning of LAWA. Thank you so very much, Mrs. Sheila Menka Premo.
Thank you for inviting me too. Thank you.
We are grateful. Also joining her is Angela Dwamena-Boagye. Thank you so much for the time.
Thank you, Samson.
Right.
We're happy to be here.
Great. So, as you may be aware, The name Menka Premo in Ghana is synonymous to legal practice or law. But this woman, together with her colleagues, have been at the forefront for many years for women to have voice as far as property is concerned. I begin with a quote from a former World Bank director, Baba Conable, which was brought to my attention by Professor Appiaje Etua of the University of Ghana. And that quote says, "Women do 2/3 of the world's work, yet they earn only 1/10 of the world's income." Only 1/10 of the world's income. And they own less than 1% of the world's property. They are among the poorest of the world's poor. How true is this statement in today's Ghana, Sheila?
It's in today's Ghana, it's quite true to quite a large extent. Women do a lot of work, but not all the work that women do is actually monetized. So at the end of the day, as the saying, for what you just read out is, it's actually reflective of what we have in Ghana. Things are changing a little bit as we're getting more and more women educated, as we're getting more and more women in the formal sector. A lot of women are able to acquire their own properties, etc. We shouldn't also forget our women in the markets. We have these big markets, the Makolas, the KJTS, etc. Majority of the people who are actually doing very well in those markets are also women. But yes, a large population of the women we have are quite poor, relatively. Even though they do work very hard, they earn very little, yes.
This statement, if it is a reflection of even today's Ghana, then this is such a sin that women do 2/3 of the world's work, yet they earn only 1/10 of the world's income and own less than 1% of the world's property and are among the poorest of the poor. What then can you say have been the steps that Ghana has taken, particularly with you, Lawa, and other women's group at the forefront in ensuring that the bridge, the gap is bridged?
Well, as far as issues to do with property rights is concerned, you're aware that in the 1992 Constitution, a clause was put in there to protect the rights of spouses. And the emphasis is not only women. In Ghana, there are very few laws that are gender specific. Most of our laws are gender neutral. The only thing is that the group that has been, sort of traditionally or customarily denied certain benefits, then they tend to enjoy more when those laws are applied. So as far as issues to do with property is concerned, I think Article 22 has been there since 1992. Parliament was supposed to come up with the law. It hasn't come up with it yet. But our Supreme Court, I would say, has taken the lead and has applied the law directly, the constitutional provisions. And I'm sure you're aware of the series of decisions that have given women. Some of them are even, almost illiterate women, but who were able to pursue their rights all the way to the Supreme Court and be given their share. Then, looking at the broader question you've indicated, I think that the efforts at girl-child education has also helped a lot, because it's seen that the more women get educated, the better they are able to protect their interests, get better jobs, are able to do better and to acquire are put in a position to acquire more properties. So I think there are a few things in place, and it may take a while to produce the result that's expected. And thinking or talking particularly about this Article 22 provision, it's been very long in coming. I personally believe that if the law was there, it would have made access to it much easier. Currently, people really have to go through the hall in courts to get access. And I know we are going to come to discussions on the land bill.
Right.
And maybe when we get there, I'll say a little bit that I know about that. Yeah.
Right. So when you said it might take a while, then I had to ask myself, how long again? Because we put in the Article 22, Clause 2, in the 1992 Constitution, 1992. And we made a commitment and said, Parliament shall, which is mandatory, as soon as practicable, as soon as practicable. How many years, soon as practicable? We are still in there, and you even give yourself the opportunity to say, it may take a while. As soon as practicable, after the coming into force of this constitution, enact legislation regulating the property rights of spouses. Then what we are all too familiar with, but many people are unaware, is the clause 3, with a view to achieving the full realization of the rights of women. A spouses shall have equal access to property jointly acquired during marriage. Assets which are jointly acquired during marriage shall be distributed equitably between the spouses upon dissolution of the marriage. So we need a law to effectuate this provision, and we still don't have. That's very sad.
Well, it is sad, but the women's rights groups in Ghana, including LAWA, I think, have done quite a bit of work. I recall that, LAWA is a small group of women lawyers who participated in some sort of additional education on women's rights issues. And since the initial set of people set up this little group to do policy proposals, we try to look for areas where there's a need for law or where the laws in place are inadequate. So one of the first things, I think the second project we did was to come up with a law on property rights of spouses. As far back as 2000. At that time, we were working with a school which was we had students who were doing some research for us. So we came up with a very detailed memorandum outlining what the problem was, indicating what other Commonwealth countries have done, and actually coming up with a text of some kind of legislation. We actually also, in around 2001, 2002, we actually tried some public interest litigation. We also put together proposals to come up with a court action for the Supreme Court to come up with a declaration on the need for such a law. And we did serve the AG then with a 1-month notice. And then we were assured that the law was going to come out very soon. So there was no need to rush. So we kind of, sort of changed our strategy and decided to go the legislative way and work with other groups and with government to ensure that we have a law in place. And the advocacy that we did actually in 2008 ended up in a bill. That was the very first draft of the bill. We worked with other groups, African Women Lawyers Association, etc. So in October 2008, the very first draft of the Property Rights of Spouses Bill was laid in Parliament by the then minister. I think it was Honorable Jogati, somebody. Yeah. But then, in 2008, we were getting close to elections. So it was actually laid in Parliament in October, but then it elapsed when that Parliament term ended. But then the new minister that came in 2009, which is Honorable Betty Modedrisu, also thought it was a very important initiative. So we also worked with her, and in the same, I think around about October, November 2009, the second, let's say, version of the bill was also laid in Parliament. And it went through first reading. We submitted a memo together with some other groups, and we met some parliamentary groups, did some, went through the bill with them, pros and cons, etc., etc. It was a very slow process. Somehow, I think they did their report. There were some parts of the bill they were not very happy with. So there was a lot of talk about what to do about it. Some of the provisions that they were not comfortable with was that, according to them, even though the Article 22 talked about spouses, that particular version of the bill also made provision for cohabitees, that is, people who have lived together for 5 years, who have held themselves out to the world as having been married, and who acquire properties together, and who then break up, that they could also apply. They were not happy with that, and they said, that particular provision was not a provision which they thought had gone beyond Article 22 provisions. And then there was, of course, at that time, there was a provision that such properties would be equally distributed. They were also not very happy with that. But for me, the text of the law itself was such that even with it, there was provision for parties to come up with their own separate property. There was actually a whole section which outlined circumstances under which even within a marriage, a person can acquire their own property. There were also special provisions on polygamous marriages. When it comes to monogamous marriages, these provisions are quite easy. But when it comes to polygamous marriages, it's very, and it's another, it creates other problems. So we helped to craft some special provisions for polygamous marriages where there will be equity amongst the women, because I don't think that we decided that we will not all come in at the same time. We will come in at different times. So there'll be equity between them, among themselves, and with the man. And then the other thing they were also not happy with were provisions of what is regarded as contribution, because a contribution in the interpretation section outlined, the law itself made a presumption that any property that is acquired in the course of a marriage is presumed to be marital property unless you're able to bring evidence to show otherwise. Okay. But then there was a section in the interpretation which defined what is contribution. So it talked about looking after a home, looking after children, working on a farm, etc. We were also not very happy with that. So the bill didn't go far. And then by 2012, it also lapsed. It didn't even go for the second reading. Then in 2013, the new minister that also took it up. I think it was, just trying to remember who it was. It was Marietta, I think.
Yeah,
so she also she took it up. And another bill was also late in Parliament in the third quarter. Similar, somehow October seems to be the time when this bill usually gets late. And we also continued working with her, did some advocacy, met the parliamentarians. And after a lot of deliberations with them, it was agreed that, fine, particularly the provision to do with cohabitees, maybe it can be taken out, because really, if you read that, because we met some judges, we met a lot of people, and they all thought that maybe for a start, it would be better to stick with a strict constitutional provision in terms of a spouse. So we were furnished with a copy of the report of the committee after their deliberations, and it was agreed, and we agreed that yes, for now they could take out the cohabitee portion, because we thought that it would be brought in much later. And then after that, so we got a letter from them confirming that this is their report. They've actually taken it out. Is that what we have the decision with Rich? We said yes, it was. And but then we didn't hear much about it again. Then there was also another lapse. 2016, there was a lapse. Then the next minister who came in, who was Madame Honorable Otiko, also took it up as a very key issue. So she also did some deliberations. She also, looked at provisions that she thought needed to be addressed, etc., etc. And we're hoping that it would have been laid in Parliament. I actually have a version. The last version of the bill I have was the 2017 version, and that version, it was just sent to us who were working on it. I think the groups that were working on it at that time, like I said, Lawa Ghana, National Women Lawyers Association. And then at that time, I was chairing the Ghana Bar Association Women and Minors Rights Committee. No, Ghana Bar Association Women and Minors Rights Committee. So they shared it with us to bring our comments. So they had taken out the part to do with cohabitees. But it was an interesting provision. The provision indicated that if there was what is called a partial customary marriage, because people's fear was that if you say cohabitees, short-term, all kinds of theories and fears were there. So this one had a section called partially completed marriage. So basically it says that where customary rights are partially performed and the parties live as husband and wife, the parties shall, upon termination of the relationship, also have equal access to property jointly acquired in the relationship and be entitled to an equal share as well. And they had a few other provisions, etc. We sent our comments on. We thought this was also better than actually taking out the whole of the cohabitation provision. So, but somehow, so we sent our comments, but it's never got laid in Parliament. So basically, historically, as far as I know, this is how far the bill has gone, and we are really hopeful that it will be taken up again. Because for me, yes, there are constitutional, there are decisions of the Supreme Court and other superior courts that actually has come up with some principles. But I think that the bill has very comprehensive principles, which will address some of the fears that are here being expressed now.
Right. So that, again, it is not left to a judge's interpretation, even though, as you say, the courts have made such a progressive, process in strides in terms of enhancing spousal women's, right to property through judicial decisions, particularly the often referred to Mensa and Mensa case.
Mensa 2012,
okay. Yeah. Right. So we take a quick breather, and then we will return to what we now find in the Lands Act, Section 47. It looks like such a good thing for spouses, more particularly to try to bridge the gap between the men and women in a marriage. But let's have Angela Dwamna-Boaji share her views briefly on what we have looked at so far. How does it feel that up to this time, since 1992, when the Constitution mandates that we should have a law that takes care of this situation so that our women are not subjected to all that we have become familiar with, we are still here?
Well, Samson, thank you for that question. I think that setting it in context is important. It doesn't feel good, and that's because it's an issue both of justice and of equity, okay? Look, I have a client I'm working with right now, and you know that I do work on domestic violence issues. Now, this client is somebody who has been with her husband several years. They have 2 children. She is known in her neighborhood as somebody who was carrying concrete, the concrete that was being used to build the house. She was carrying this concrete on her head, laying blocks and paint, everything that had to do with this little house they were building. Now, for some reason, this man ups and goes away, finds somebody else, goes to another community, and is trying to sell the house. Practically speaking, from time to time, he will send people to the house to threaten his wife. He will send people to say, look, I bought this house, you have to move out of this place. Sometimes she will call me, I'll tell her, run to the nearest police station and report that you are being threatened. And this is the kind of practical situation that the law seeks to provide for. Okay, look at the case of Corte and Mate, 1957, where the judge actually said that a woman is supposed to help her husband in his station of life. But she has no, I wish I could just quote it, let me say this. He said, by customary law, it is the domestic responsibility of a man's wife and children to assist him in the carrying out of the duties of the station of life, his station in life. Example, farming or business. The proceeds of this joint effort of a man and his wife and or children, and any property which the man acquires with such proceeds are by customary law the individual property of the man. It is not the joint property of the man and his wife or his children. The right of the wife and the children is a right to maintenance and support from the husband and father.
Obviously, very backward thinking. That is the
context from where we are coming. If we don't set it in context, people think, oh, the women, they are greedy for money. They desire to take over their husband's properties. I'm telling you, all of our husbands think like that, one way or the other. But it is a spouse's, not just the woman's, property rights, and this is emanating out of a situation of injustice and a lot of cruelty sometimes. You know the Ribeiro and Ribeiro case. 10 houses the man has. On divorce, he says, I won't give you even one. And from High Court to Supreme Court, this man was fighting that he won't give his wife long-standing years of toil and labor, even one house out of 10 houses. And the court says you can't do that, from High Court to Supreme Court. This is the context within which we are talking about these things.
So, like we started, you know, Sheila mentioned women doing work that is not monetized. And
yes.
I hope you could help us to understand that, because as a married man, I understand what it means, or I have come to understand what it means to have the peace to go to work because my wife will take care of the children.
Yes, and that is the reality of our existence and living. I mean, domestic roles since the time of Adam and Eve, you know, it's been there. As to whether it was God who made it, so that's another argument altogether. But like women are expected to take care of the home and the children and all of that. Nobody does these things and ask for receipts. If we were to hire nannies, bring in washing machines, bring in security officers, bring in nurses, all the work that women do in this country, if we were to monetize it, we will understand the amount of money that that will go into ventures like this. And that is why the judges are repeatedly saying that now you don't even have to show that you actually can produce a receipt, that when I went to market and I bought tomatoes, my husband was building, he used his money and I used my money for tomatoes. So please, tomato seller, give me receipt. No woman has those receipts. And yet they contribute tremendously from morning first to wake up, last to go to sleep. It is still a reality of our lives, okay? So why don't we take these things into consideration when it comes to issues like these? If we understood, okay, here, let me just put on my pastor's hat. If we understood the purpose of marriage, this would never have been an issue. It is because we don't understand the purpose of marriage and the kind of relationship that we are supposed to have with spouses. That is why this is an issue. That is why there are divorces. That is why there are people throwing people out of their homes when their spouses die. And that's why the law has to take care of these things. We can't ignore it. It's a matter of justice.
Right. So as you mentioned, we have gone from the backward thinking where, including in Randolph, the court's view was that you must have made substantial contribution as a woman to the property that was acquired before you can be entitled to any part of it, to our present day Supreme Court, you know, giving such a boost to the provision of the law and stating that the sharing of spousal property should no longer be dependent on substantial contribution principle, and that the property acquired during marriage is joint property even if the spouse did not make any contribution, and that a spouse, where it is equitable and just, may be entitled to an equal share in the said property, looking at the contribution they make by all the things they do, taking care of the home and everything else. Why is it important to have legislation for the situation rather than relying on the market improvement, advancement that the Supreme Court has made in this area?
In fact, Samson, if you ask me, I do have my own concerns about whether legislation is the way to go or to let the Supreme Court, you know, continue to advance what it's doing, because it's done very well so far. The only thing I realize, though, is that sometimes the courts will give with one hand and take with the other hand. Even the equal principle was challenged further when the courts seem to have given a ruling, and I've forgotten what case that is, whether it's Watson or Patton, one of those, that, you know, we'll go case by case. It was equal. Then in the next case, it was like, no, we can't make it equal. We need to look at all the circumstances and do case by case. And that is the thing about when people have to make decisions, you know, based on sometimes what they are also thinking about in a particular moment or their own inclinations. And, you know, it's tricky. And that's where law steps in to make it more certain. Okay, so yes, if I look at the advancement of the law, I would say, let it slide. Let them go on. The judges are making law, and we waited for this for over how many years? So let them, and they're doing quite well. However, the uncertainty in the kinds of judgments that may come, depending on who is doing it and all of that, is also there. And that's where legislation may come in to help. But the disadvantage is that we also have a whole parliament of 275 people who have to decide on this thing. And I tell you, because of our cultural circumstances and the things that have happened, when it comes to relationships of marriage and so on, and how people want to do their stuff, all of that is coming up against this law. They told us, in fact, I remember clearly, I don't know if Sheila remembers it, and I'll end here, that, you people think you had a long time with the Domestic Violence Act and we gave you a tough time. Wait until the Spousal Property Rights Bill comes up. Then we will show you our mettle. I mean, if you say things like this, it just tells you, the kind of thinking that a lot of people have about some of these things.
Thank you so very much. And if you are just joining us, we are looking at the question of spousal property rights. More particularly, we are now zooming onto the Lands Act, a new law that has been made that appears to have made such a great inroad, if you like, into the right of women in having equity in property. We will take a quick break. When we return, you will hear, continue to hear Mrs. Sheila Menka Premo, and also Angela Dwamnabwaji, both of Lawa, Ghana. And Sheila is also the managing consultant of Apex Law Consults. We'll be right back. You're welcome back. This is The Law, and we are discussing spousal property rights, asking the question whether the keys have been handed to women. And we give you a reason why we ask that question. My guest is Sheila Menka Premo. And so let's look at the new law. It's the Land Act 2020. And there is this particular provision that we are bringing to your attention right now is Section 47. The Section 47 of the law says, except as provided in subsection 3 and 4 of Section 38, in the absence of a written agreement, to the contrary by the spouses in a marriage, a spouse shall not, in respect of the land, right or interest in a land acquired for valuable consideration during marriage, sell, exchange, transfer, mortgage, or lease the land, right or interest in the land, enter into a contract for sale, exchange, transfer, mortgage, or lease of the land, right or interest in the land, give away the land, right or interest in the land, inter vivos, or enter into any other transaction in relation to the land, right or interest in the land, without the written consent of the other spouse, which consent shall not be unreasonably withheld. Sheila, the question to ask now is, I've heard people suggest this is controversial, but the question to ask now is this clearly not one way or sort of a backdoor approach to get all that is deserving and has been fought for over the years?
Thank you very much. Maybe as an introduction, I would say that I had the privilege to be sitting at the table when the Land Act was being drafted. And at that time, I was doing some consulting work at the Ministry of Lands. And in addition to that, I've also had the opportunity to also work with the Network for Women's Rights, Net Rights, in promoting what they call the gender equality and social inclusive provisions in the Land Act. So I've done a little bit of work. As far as the land bill is concerned, I mean, the land bill which resulted in the Act 1036 is
That's
concerned.
right.
It has a long history, and it was developed as part of the Land Administration Project, like I said, yeah. And under the Land Administration Project, it's a long Government of Ghana project that is aimed at trying to address the problems that we have with land administration in Ghana, and to put into effect the 1999 land policy, national land policy. Some of the things that was realized in the national land, when you do a policy, you try to identify what are the problems, what are the issues, so that when you are going to do legislation, it will guide you. So they had seen that there was a lot of inequity, there was a lot of unfairness, there was a lot of inefficiency, and there was a need to do what would be required to address some of these problems. So in the memorandum to the land bill, which is very comprehensive and which they did a lot of consultations. I attended some of the consultations they did with traditional authorities, with different sectors of the population. The memorandum is very clear. One of the provisions that is cited in the memorandum is Article 22. Remember, I said that one of the goals of the land administration of the land administration project was to ensure that they address things to ensure that there was fairness, equity, efficiency, etc. So as far as the land bill, which was one of the outputs of the land administration project, is concerned, they indicated that when it comes to land, the current legislation in Ghana, there wasn't clarity in many things. And then they indicated clearly that Article 22 of the Constitution actually mentioned Article 22. So if I may read a little bit of the some parts of it, it says
Please
that. So it's further observed that the 1992 Constitution and its directive principles of state policy embodies most of the principles covered by the international protocols and guidelines that are found expression in the bill. The bill has extensively been subjected to overriding articles of the Constitution. In pursuance of Article 20 of the Constitution and international best practice, the bill provides that property apart from valuable consideration by spouses during marriage, virtually recites the key provisions in Article 22, which they said should be reflected in this bill that was being drafted. Again, they also mentioned the key provisions. It says the bill further provides for the consent of spouses in the disposition of such property. And these provisions mainly reflect recent decisions of the Supreme Court. They mentioned the Mensa Mensas, the Boafo Boafo. Incidentally, one of the members of the working group was a Supreme Court, and it was a retired Supreme Court Judge, Justice Broby, and he was very vocal about this. He says that if you look at Article 11 of the 1992 Constitution, it talks about the sources of law in Ghana, and decisions of the superior courts are parts of the laws of Ghana. So in terms of the interpretation of Article 22, they mentioned, so they've actually cited a number of these cases, which have become part and parcel of the laws of the country because they've been determined by the highest court of the land. So it was indicated clearly that they should be reflected. So to be honest, like I said, I sat in there not as a gender expert. I was there doing something on customary law with the National House of Chiefs. And as a result of that, I had to say, I had the privilege of being at the working group. But in the drafting, these are some of the things they took into consideration. Now, with regard to the article, section 47 that you mentioned, when you are interpreting a statute, you have to look at it in whole.
That's right.
So before we look at 47, to make 47 make sense, you need to look at section 38. I think that you deemed it in your presentation.
That's right.
That is what makes sense. So the provisions on the presumption, that presumption that we have in Article 22, which is that properties which are jointly acquired in the course of a marriage are supposed to be jointly owned, and therefore both parties are supposed to have access, and it should be equitably distributed. It is reflected in 38, particularly I would say from 38 to 3. It says that in a conveyance of valuable consideration of an interest in land to a spouse during marriage, the spouses shall be deemed to be parties in the conveyance unless a contrary intention. So there's a presumption, unless there's a contrary intention. And then where contrary to subsection 3, a conveyance is made to only one spouse. That spouse shall be presumed to be holding the land or interest in land in trust for the spouses, unless a contrary intention. So basically, it is a reflection of, I would say, Article 22, because, as I said, when they were drafting, they didn't ask for a copy of the Property Rights of Spouses Bill. They just looked at Article 22. They looked at the Supreme Court's decisions that have been made, and they put text in to reflect this.
So rendered in very simple language to all who are listening and watching to us now, what does this mean?
So it just says that if properties are acquired in the course of a marriage, there's a presumption. It is presumed that it's supposed to be owned by the two, unless there is expressly stated that no, it's for only one person.
Right.
So unless the parties themselves say that it is for only one person. Then it goes on in 47. 47, which is what you started off this question with.
Right.
Which is, if you're going to dispose of your interest or encumber it in any way, then there's a need to get the written consent of the other spouse. The other spouse either has if it is in the joint names, the other spouse has a legal interest. If it is not even in the joint names, the other spouse is presumed to have an equitable interest. And therefore, if anything is going to be done which would jeopardize that person's interest, the law is saying that person should have a say in it. So that really explains the text of 47. And actually, these provisions goes on even further. If you look at section 97, it goes on to indicate that there are further provisions which actually actualizes these provisions. It indicates, for instance, in 97.4 that an application for registration of land or an interest in land acquired for valuable consideration during marriage shall state the spouses in the marriage as the applicants unless a contrary intention is expressed in the conveyance. And then 5, where only one of the spouses is stated as the applicant, that spouse shall be presumed to have applied on behalf of that spouse and the other spouse. So it's a continuation. So from what I learned on the table when this law was being drafted, the Land Commission is going to come up with forms, and the forms will be some of the prerequisites to registration of a conveyance or an interest in land. And one of the things they would ask you for is whether or not you're married. If you're married, then they would find out whether the other person, there's any documentation which shows that the other person doesn't have an interest in it, etc., etc. So these are provisions which are aimed at sort of carrying forward the provisions in Article 22.
All right. So how much of help do these provisions do to spousal property rights? Particularly, we're talking about advancing in the interests of women, because they have been at the disadvantage all this while.
I think that it would help to some extent. It will help to some extent, but I believe that there would still be challenges. For instance, if the way this, I know it's a new law. You don't want to be hearing about the challenges, etc., but some of these things are real. When it actually comes to polygamous marriages, okay, how is this going to be applied? Do you see it? So for me, the provisions of the Property Rights of Spouses, I know, as Angela indicated, getting that full Property Rights of Spouses bill through is going to be challenging. But for me, the additional provisions in it will make the spousal rights thing, whether it's for a man or a woman, because right now, I'm sure you're aware that there are also men who are now going to court. I handled a case where it was a man who was making a claim for properties that the woman was in the woman's name, saying that he had an interest. So
right.
I know we emphasize, yes, women are more vulnerable, majority, as we indicated from the beginning, but increasingly other people are also coming in, other men are also coming in and trying to make claims based on these provisions.
Right.
So for me, I think that the Property Rights of Spouses Bill has a lot more additional provisions that, if well understood, will put people's mind at ease. For instance, to know that if for instance, you're preparing a vesting assent, okay? Vesting assent, you usually prepare it when somebody is inheriting something or property is being it's being transferred by virtue of death, etc. Of course, that one, another spouse's name doesn't have to be there. And it's clearly spelled. Those things are more clearer in there. It also clearly indicates what can constitute separate property. And for me, another interesting provision in the Property Rights of Spouses Bill, which we've not spoken about, is it gives the parties the right to come up with what they call marital property agreements. So at the onset of the marriage, the parties themselves can sign, hey, this is my property, this is yours. It's when we're going to acquire, when any property is being acquired in the course of the marriage, unless you contribute, all those things can be put in there. So it gives the parties themselves the right to come up with their own rules to guide property acquisition so that it doesn't become a thorny point in the marriage,
Thank you.
So I think that there are lots of the polygamous provisions on polygamous marriages, which for me are also more clearer and then would actually help in those circumstances.
Okay.
It's more extensive.
Let's take Angela's views quickly on this, and then I'll pick a couple of questions or contributions from our viewers who are watching now. Now, so Angela, how should we celebrate this? That once property is acquired during the marriage, there's a presumption, unless a contrary view is expressed, there's a presumption that the property belongs to husband and wife, and therefore one of them cannot sell the property, cannot exchange it, cannot transfer it, cannot mortgage it, cannot lease it, or try to use it to enter into any contract or whatever it is without, or give it away without the written consent of the other spouse.
In fact, I think that it's quite a landmark thing that should be celebrated, except that on one hand, it makes you happy, on the other hand, it makes you sad. Because it's like, why did we have to come to this? Okay, that's not the way things are supposed to be, but we've come to this. And some of us have personal experiences from our past where our parents, sold property like that without the input of the other person, okay? And then other people say, but why are you sitting down for him to do that to you? And it's like, I'm a wife. What can I say? If I say anything about the property, they'll say I'm greedy, and things like that. They sit down. We suffered as a result of those things. Okay, we suffered, and it's a personal thing. And it's not only, I'm not the only person who has an experience like this. Other people had similar experiences. So really, it's something to celebrate. But of course, we cannot also be unmindful of the fact that where polygamous marriages are concerned, like Sheila was saying, it's going to be a problem unless, you read this particular provision alongside with the hopefully soon to be passed Property Rights of Spouses bill. Otherwise, standing alone, it might cause a lot of problems. How many wives are going to sign on to something? How, whose interest is what in what? It can be murky.
All right, but in the scheme of things, this is quite progressive. Now we can take your questions or views quickly. We have a few minutes to do that. We can spend some 5 minutes to take your views, so you can call in and let's hear your question or what you have to say about this new development. So if you have not been aware, since this law was given assent to by the president, and the date of Gazette notification is the 23rd of December 2020. That is the date of Gazette notification. From that date onwards, this is the rights that spouses enjoy as far as property that is made during a marriage is concerned. So who do we have first with a question or contribution? Okay, we just lost you there. You can call back, and those of you ahead of the program who wanted to also contribute, the lines are open now. You can join us and let us know what you think about this. And remember, as Sheila emphasized, it is spouses, so it goes both ways. It is not for women, so to speak. And as we are beginning to understand, some men are also going to court when a marriage is being dissolved, asking to have a portion or, yes, to have a portion of property that belongs or is done by a woman, so to speak. Right. Hello, Ernest. Let's hear your question or contribution quickly.
Hello. Hello, Thompson.
Go ahead, mute the set you are using and speak directly.
This is an interesting discussion. In fact, when these laws are passed, media, in one way or the other way, do not give us education. So it's very good today you brought this issue up. So I would like to ask, so does it mean that if me and my wife have a property, and now I want to use that property as a mortgage, I have to do that with the consent of my wife, or what? I don't want to get that side.
Okay, thank you very much. That question will be answered by Sheila shortly, whether you need a consent. We have Gladys. Hello, Gladys.
Yeah, and I have some problem to discuss with you people. I married and I stay with a man almost 20 years. And he go and marry another woman. Now we stay at a house. Now the man put me in this boys' quarters and hire the self-contained. Meanwhile, I stay with him some years. We have 4 children. And now I'm in this place, boys' quarters, and we have a container. I need your help.
Okay, thank you for that. That's maybe a different issue. I'll take a very last, Adams. Hello, Adams. Hello, Adams. Okay, hello. Okay, so Sheila, can we respond to Hello, Adams. You have just some 30 seconds. Go ahead.
Okay, I want to find out if we are living together. Hello?
Go ahead.
So I'm saying that if you are living together as husband and wife, and the husband is actually acquiring his property, and the woman is also acquiring his property by sending it to the father's place. So in case of that, if I want to use my property, he has no business of me alerting her.
All right, thank you very much. Your question is noted. Okay, so the question from Ernest was, does he need the wife's consent?
Yes. The law, thank you. The law is very clear. The current legislation you read out, that is 47 sub A. Yes, you would need her consent. And I'm sure that with time, the banks and various places are going to now ask for it. So yes, he'll have to start talking to his wife so that.
And the law actually says written consent.
Written consent, yes. They will need a written consent. That's what the law says.
Right.
It says written consent.
Were you able to decipher the specific question in Adams's narration he gave?
So basically, well, what I gathered was he said he's acquiring property. His wife has also acquired property, but she did it in her father's hometown.
Yeah. Okay.
So does she have a say in what he's doing? I think that the two of them should be able to sit down. Okay. Each of them have been able to acquire if the understanding is clear, and it should be good. If they won't even write it down, there should be some third party to serve us away.
Okay.
Then she knows that hers is hers and then his is his.
Thank you.
This is how they agree on these things.
Thank you very much. Yes, thank you very much. Unfortunately, this is where time brings us. I'm so grateful. We thank you so very much, Mrs. Sheila Menka Premo, Executive Chair, Executive Council of LAWA, Ghana, and Managing Consultant of Apex Law Consult. Also, Angela Dwamnabwaji, thank you so very much. And Ghana actually is indebted to you at LAWA for the work you have been doing to improve the status of women as far as their rights are concerned in every sphere of life. Thank you so very much. And once again, LAWA is leadership and advocacy for women in Africa. These have been my guests. Join us again next week for another interesting edition of The Law. This is your Legal Light and Health Law. I'm Samson Ladi Anyanini.